Hello, hi guys. Myself again Meenakshi, currently working as law associate in LEXIS and Company. In this current video, we are going to talk over the topic what type of evidences are there while framing the cause of action in a civil suits, and what type of the parties are going to be involved in the civil suit. So, in any civil suit, prior framing the same, we have to take the brief of the same, and while taking the brief, we had already discussed we are going to quote the facts in according to the list of dates and events, and in order to corroborate the list of dates and events, we have to quote some evidences. So evidences can be in two forms, either in documentary or in the witness based. So if it's in documentary form, we are going to peruse before the court the documents in a appropriate form, like if in the photo state, in the two photo state form, or in if the court requires in original form. And if within a witness form, we have to quote the statement of the witnesses, whichever is relevant according to the cause of action we had quoted while seeking relief before the concerned court. So beside the evidences, the next things we have to foresee is that the whosoever is going to make the concerned parties means the person who is going to seek the relief going to be called as plaintiff in a civil suit, and against whom he is going to approach the concerned court for seeking the relief, he is going to be stated as a defendant. So basically, in any civil suit, there are two parties. In a layman language, we can say one is plaintiff and one is defendant. And what we have to foresee is that who are going to be the plaintiff. In many civil suits, there are two plaintiffs or three plaintiffs in accordance to the facts in issue, and in accordance to that, whatever cause of action has arose. So we have to foresee how many plaintiffs are going to be there before the court, and against whom they are seeking the relief, how many defendants are going to be there. And after fixation of the same, we are going to file a civil suit before the concerned court by quoting the number of plaintiffs and number of defendants according to the relief we have quoted in the form of prayer. And post that, we have to foresee the prayer, which is the foremost and the prerequisite for any civil suit, as it is going to decide what kind of relief we are going to be extracted or we are going to be received from the court, as the court has always awarded the relief in accordance to the prayer clause we had mentioned in our civil suits. So prior quoting the prayer clause, we have to see whether the relief that we are going to sought is not barred by any limitation, and if so, we have to see what type of relief are there, so that it is we can correct the prayer. So in the limitation clause, we had many reliefs are there. If the relief is going to be barred through the law of limitation, we have to file a condonation of delay, but it is the sole discretion of the court to accept such type of application. If the court is not at all satisfied to condone the delay, they can dismiss the suit at the same time. But we have to approach and we have to convince the court in accordance to the condonation delay application in such a manner that the court is getting convinced over the reason that we have laid down before the court, so that they are going to condone the delay we had caused while filing the suit, so that our prayer is not going to be barred in accordance to the law of limitation. So while in case in this scenario, we understand that if our prayer is going to be barred to the law of limitation, we have to foresee the recourse that is available. So to correct the same. So there in the law, although the limitation period has been mentioned for every sort of relief, but in the same time, the resort is also presented. So while prior quoting the relief, we have to foresee whether it is barred by any law of limitation, and if so, we have to resort the recourse at the same time. Thanks for now, guys.